Is it really just us?
She's letting in other folks after the
Right.
members ring. Go ahead, Julie.
Right now, it is just the board members. I will start letting other people in, but I'll give you a heads up. If you
Okay.
want to say anything now, quick, but
No.
okay. If you guys are okay, I'm gonna go ahead and let a bunch of people in, then I'm gonna start Facebook, okay?
That
No,
works.
we're still waiting for, who are we waiting for? Mark and Kate
And
Yep.
Bill, correct?
and Bill.
Yeah, and Bill, right.
Okay, and I don't see any of them in the waiting room at the moment. But I'll give it until 6:59 if that's okay, and then I'll just start letting people in. And
I
I'll
would
start the
appreciate that.
recording.
Yeah.
Oh, here comes Mark.
John, has the chief been invited for the second part of the closed session?
I don't know. Brian?
Because she was in on some of the discussion before. I only asked because I don't see her.
Brian, you're muted for some reason, even though you unmuted.
Can't hear me?
Now we can.
Now we can.
Yep.
No, I said I would text her when we get closer to that session so she could join.
Okay, I'm gonna start letting in all of our guests, and then I'm gonna start the Facebook, everyone.
Okay. Thanks, Julie.
I'm trying. Can I be heard, John?
Yes,
Oh, okay. I'll go back on mute. Thank you.
thanks. You bet.
Okay, it looks like we are live on Facebook, John, so whenever you're ready.
Okay. All right, welcome.
Can I ask anyone who is not a board member to turn off their camera just so that we can see everyone on the screen until you're speaking?
I'm gonna leave mine on if that's okay, Julie.
Well,
Right now.
yeah, I'd like all the board members. It's just all
Okay.
our guests, if they could turn their cameras off until they're
Yeah. Got it.
Thank you.
All right, ready to go?
So I'll turn my camera off as Julie asked, but am I the only one other than the trustees who are here?
No, there's a big group of folks here, Marilyn.
Oh, I'm sorry, John. I guess I just don't see that, I guess.
Okay.
Okay, thank you.
Yep. All right, Julie, we're gonna call the meeting in order then.
Yes.
Well, all right, welcome everyone. This is a special meeting of the Village of Sherwood Hills Board of Trustees. Tonight is Wednesday, August 6th, 2025. It is 7:01 p.m. We're doing it virtual tonight. Let's call the meeting to order. Julie, can you do the roll call?
Yes, President Imes,
Present.
Carol Barford,
Here.
Dietmar Basuna,
Present.
Bob Falk,
Here.
Mark Lederer,
Here.
Shabnam Lutfi,
Here.
Kate Ulsvik.
Here.
Okay, that is all our board members.
Okay, item 3, approval of the agenda. Do we have a motion? Dietmar.
Yep, I so move the agenda as presented.
Okay, second on that. Thank you, Kate. All those in favor, please say aye or raise your hand. The agenda is approved. Statement of public notice. Brian, Julie, just want to confirm that the meeting was properly noticed.
Yes, it was.
Okay. Item 5, procedures orientation. Just want to remind folks that this meeting is also being broadcast on the village's Facebook page, on Facebook Live. Comments or questions made on that site won't be viewed by the board during this meeting. Questions or comments should instead be sent to our village administrator, Brian Mooney, as we can't respond to them or look at them contemporaneously. All right, item 6, public comments. This is an opportunity for community members to speak to the board. No discussion or action may take place at this time, though trustees may ask clarifying questions. And I just want to say, just at the front end here, you know, we certainly we truly appreciate the time and thought everyone has put into sharing their perspectives, the emails, the letters, the information Craig Weinhold has put together. And of course, as a board and as individuals, we've carefully reviewed the materials submitted by Mr. Clancy. This evening's public comment is an opportunity to add any new insights or information that hasn't already been covered. To ensure everyone has a chance to be heard and we can make the best use of our time together, we kindly ask that comments be kept to a few minutes so we can focus on the board discussion with our attorney and potential decisions and how we'll keep the community informed on this moving forward. So with that, I'll ask, are there any public comments this evening? And if you could just raise your hand electronically or physically, we'll try to find you. Hey, Mary Tupper.
Hello. I've prepared a written statement of some of my
Okay.
thoughts. I've shared with some folks, but I just want to make sure the whole board is aware. So should I just begin?
You bet.
I can't hear anything now. Okay.
Yes.
Okay. I'm a Shorewood Hills resident who regularly works in the village in my professional role as a residential architect. Last October, a client of mine asked me to perform a simple zoning analysis on Roseanne's house and lots, and I gathered all the information from the assessor's website and a survey that Roseanne had provided my client, and I unfortunately informed her that there would be no possible subdivision of the land if my client wanted to use the attic as habitable space. She ultimately did not put in an offer to purchase the house. It is from this perspective that I'm speaking to you today. The fairness and reliability of municipal zoning decisions depend not just on accurate, but validated data. I believe it's the role of zoning review staff to review applicants' supporting materials, identify red flags, confirm data, confirm real-world conditions, and invite scrutiny and counter evidence through public hearings as necessary. At this point, the only measured drawing available to the public is the one from the assessor's website. And if we compare Reber's submitted square footage to this publicly known data, he underestimated the total square footage by 440 square feet, which is basically the size of a 2-car garage. Additionally, the LLC completely excluded the 800 square feet of the attic from their calcs, claiming that this would be inaccessible and unused, whereas in reality, the attic remains fully accessible and is actively in use, showing that the applicant's assurances were not just incorrect, but potentially misleading. When the attic is correctly included, the square footage exceeds the allowable FAR of the newly subdivided lot by 27%. Typically, zoning reviewers require that qualified architects, engineers, or drafting professionals submit measurements to ensure that decisions are based on fair and accurate data. And it's troubling to me that this basic step seems to have been neglected, allowing questionable numbers, effectively unverified figures, to form the basis for approving a significant subdivision. The consequences of this oversight reach beyond simple errors. The absence of proper due diligence undermines the transparency and credibility of the zoning review process. and approvals based on flawed or inaccurate data set a concerning precedent, suggesting that essential zoning standards might be treated as optional or even worse, negotiable based on misinformation. Therefore, I believe it's essential that the village board address and correct not only the procedural failure, but that prompt action is necessary to ensure accountability and restore the public confidence in the zoning and oversight practices of the village of Shorewood Hills. Thank you.
Thanks for that, Mary. And can we get a copy of your comments? Can you forward those to Brian Mooney or forward them to me and I'll get them to staff, you know, however you'd like to handle it.
Sure.
Okay, thanks so much. Are there other additional public comments this evening?
John, do you see that Michael VL has his hand raised?
I do now. Michael Van Lanningham, am I guessing right there?
Yes. Can you hear me, John?
Yep,
Just
go
want to
ahead.
make sure.
Yep,
Okay.
yep.
Hi. Thanks. I just wanted to echo some of the comments I made in a more detailed email to the trustees earlier today. I know there are probably a lot of residents upset with the change, moving from a wooded lot on the area of the CSM to a lot that now has no woods and that will have houses. 100 years ago, there were no trees and there were also no houses on that lot. Things change in the village, as does zoning code. We can't apply zoning code that we want to be in place to the past. And I think I echo some of Mary's comments when she says this. At the time of the CSM, the village allowed for property owners to modify their space, removing parts of square footage from the FAR calculations. It allowed for lot subdivisions and for tree removal. The CSM was done after all of these things. The developer in question pulled permits to remove the attic and make it dead space for the FAR calculation. The CSM was introduced at the Plans Commission, as I know many of you know, and it went through and was approved by the Board of the Trustees. All of these meetings were properly noticed, and it's unfortunate that some residents feel left out of that process, but that process was public. I don't know the developer. I have no financial ties to the developer, but it makes me uncomfortable that what amounts to hearsay have turned into claims that would be used by the board because of a outcry of a small number of residents to deprive somebody of property, actually two people of property at this point, because the home is now owned by another owner. And so I know some of the claims relate to whether or not the attic was removed from dead space, but that work was permitted and performed. Even if the developer had mentioned this this dead space attic might make a nice children's room, how many realtors will tell you this attic could be finished? That doesn't constitute municipal approval for work. It does not constitute making that domicile a non-conforming domicile on the lot with the FAR calculation. If that work was performed by another owner, that is not the legal responsibility of the developer who sold it. So I just want all of this discussion to be informed by the fact of what was legally allowed at the time and who owns the properties now. And if the village were to rescind the CSM, there would be serious legal consequences, including potential litigation that might cost hundreds of thousands of dollars or millions if the village is required to purchase this land through eminent domain. Because both property owners now of both lots would be deprived of their titles, which are recorded in Dane County. The owners of the home might have their note called. And so all of this should be considered that perhaps there was an administrative error, as Mary mentioned, but is that administrative error worth remedying with a scorched earth approach? Thank you for your time.
Thank you, Michael. Next up, I see Marilyn Townsend has her hand up.
I do. Can folks hear me?
Hear and see you.
All right. I notice there are two issues on the closed session tonight. And as I have at the last two board meetings, I have a continuing objection to the closed session regarding acquisition of lands for public facilities. As a resident, I am registering my continuing concern that the board is withholding from the residents all information to the possible purchase of real estate by the village for unidentified public facilities. Its justification, as stated by the president at the initial closed session, which was at the June 17th board meeting, was in order to discuss the village's bargaining position with respect to its negotiations with the property owner in a manner so that the owner is not privy to the village board's direction to its negotiating team concerning possible purchase of real estate by the village for public facilities. That is all, as far as I knew, the trustees knew at the moment. It's certainly as much as the public knew. Nonetheless, without any discussion whatsoever, 6 of the trustees, 1 was absent, voted to go into closed meeting. I think that in itself is chilling, because it is not enough to simply recite a statute in a general statement that fails to identify anything and justify that for secret meetings. While I can understand that perhaps a limited closed session may be proper so the owner is not privy to the village board's, quote, as the president said, direction to its negotiating team, quote, concerning possible purchase of real estate. The time, now that we're going into the 3rd month with absolutely no information to the public, has long passed. I see no justification for a 3rd closed session meeting, which I believe, based on what I know as an attorney who for over 30 years has worked with public records, that there's a justification in the open meetings laws for a session which keeps secret from residents and the taxpayers of our community the identity of the real estate, the owner of such real estate, and the kind of public facilities that may be involved. In response to a similar objection I made at the last board meeting, 2 of the trustees responded. One trustee said, "I just want to respond to Marilyn's comment with respect to the closed session. We did consult with outside counsel on that issue. I remind you, trustees, you can get advice from outside counsel, but the law holds you responsible for evaluating the information based on what you're given and deciding, not on advice of counsel, but based on the information you're given, whether a dramatic closed session is warranted." The trustee went on to say, "We were advised by counsel, and that's our position on that subject." The other thing I want to say in that same regard is that personally, it would be extremely unlikely. I cannot imagine circumstances where I would vote in support of the acquisition of a property without the public being informed and taking consultation from the public. Well, there was a major Wisconsin municipality was found in violation of the open meetings law because they said, listen, and that was the city of Milton. They said, we are going to give the public a chance to weigh in. But in the meantime, we need these secret negotiations concerning the siting of a proposed ethanol plant. The court stated that Milton's argument that it included contingencies in the final approval of the plant development to allow for public input is unavailing. Milton has cited no authority, nor have we discovered any, allowing an exception to the requirement of open meetings on the basis of opportunity for future public input. That Milton fears a possible disruption of its plans is not reason to avoid public debate through secret meetings. Indeed, contentious issues are those most in the need of public discussion. So again, tonight there is a third closed meeting, which started back in June, which basically gave the public and the trustees who voted to go into favor of that no direction other than it dealt with unidentified property owner, unidentified property, that we wanted to give direction to the negotiating team. I subsequently asked for records that identifies the negotiating team. It was pro forma denied. Again, after being a trustee for 12 years, there were many times we could have gone into closed session, but we did not. Closed sessions are not mandatory. They are permissive based on a very narrow standard. So again, I continue my continuing objection. I want to make an open records request right now for all legal authority that the two trustees were referencing from Village Council in the last meeting, which they believe justified, as one person said, the opportunity to get input later on down the road. So thank you. That's all I have.
Thank you, Marilyn. Are there other public comments this evening?
No. Audio, video.
I see Scott Ross Baker has his hand up. We're
It's
gonna go.
disabled
Can you focus?
by the host.
If you could mute your microphone so the board can hear the public comments. Scott, I'm gonna go to you next. Scott Ross Baker.
Hi. Yeah, so my wife Lisa and I and our family have been very happy to be welcomed into the village and the community the last few months. So we didn't know that we were getting into a contentious purchase when we bought 2816 Columbia and the adjoining lot on Dartmouth. I don't have any prepared statement about the CSM issue, but I just wanted to tell the board, my wife and I are very happy to answer any questions of fact or kind of otherwise that the board may have about any of the actions or information that were relayed to us as part of the showings of the house prior to the purchase or the offers or the purchase or contingencies kind of related to that. So if there are any questions kind of now or later on as they come up, happy to help wherever we can. Thanks.
Scott, really appreciate that. Glad that you're able to join the meeting tonight, and welcome to the village.
Thanks very much.
All right.
We're happy to be here.
Yeah, awesome. Oh, thanks, Lisa. Great. Glad you could both join. So, are there other public comments this evening? I'm scanning.
Hello?
Yes. John, did you
This
want
is
to
John
speak?
Clancy.
Yeah, go ahead, John.
Sorry, I didn't know how to raise my hand. I apologize.
No worries.
So I first just wanted to thank the board for getting together on this issue. Obviously, we've been very involved in this and submitted a couple documents about it. I just wanted to make sure we're on the same page on a couple issues just before you go into session. I think this is clear from the meetings we've had and what we submitted that what we're raising is not about the ZBA meeting, which might occur in the near future. Oh, sorry. Start video.
I'll do it.
I think I need it over here. Is it on now? Okay, great.
There
Sorry
you are.
about that.
Yep. No worries.
So yeah, but thank you for conducting this meeting, first of all. And then secondly, I just wanted to talk about a couple of things. One is, I think this is pretty clear now, based on the past board meeting and what we submitted, that what we're raising in these documents is not a ZBA issue. So not, for the 1206, I think it is property that has a building permit. It's not also about trying to, amend the ordinances going forward, which which is an important thing to do as well, and not asking for like a moratorium on development in general in the city, in the village, but instead relates to the CSM, the division of the property. And our concern here is, really not so much, it's not that a bunch of neighbors are mad about, what happened and that's it. It's that we're really concerned about how that division occurred and the representations that were made that the third floor space was made inaccessible when it appears, to me at least, clear that it was not. It's not, I didn't catch the name of the person who spoke, indicating that they had concerns that, the process is what it was and the attic was made inaccessible and now people are complaining. We're complaining, frankly, because the attic appears to have never been made inaccessible. There appears to be a permit that was pulled, but in looking at the pictures that photographs that the owners now, the Bakers, provided to us generously, make clear that the property was marketed as having open access to the third floor. There is no impediment to going upstairs. In fact, they fixed up the third floor. And talking to Roseanne, the flooring that's shown there, the new flooring was not in there because of her. It was because of the Reber family LLC. And it was actually staged as a children's play area. So it's not that we're complaining and saying against what the village would normally do, which might be, it's still unclear in this, to allow folks that make an accessible third floor area to not include it in the FAR, but it's that they never did that. Or if they did it partially, they then removed it and sold the property as an open third floor. And I don't think there's any, because of that, there's not a risk. There should not be any risk to the Bakers. They didn't do it. It appears the Rebers did that. Also, we believe based on that, I think the group of, neighbors that are online here, and a lot of them I think are not going to speak because we just want to let you get to your work, frankly. But they asked me to just say a few words about what our basic concerns are. We think that's pretty clear that this should just be rescinded the way it is. We could understand that you might want to do a factual investigation. If that's done, I think that I think it was Ron Smith who sent in an email to the board noting that it's really important if you do that you have someone who can take a down testimony that's under oath, and you can understand exactly what happened, and you can decide what should be done, both with rescission and then perhaps legal action against the Reber family LLC if they truly, lied to the village and said that they made the attic inaccessible when they didn't, and then they marketed the property as having not only an accessible third floor, but one that is, fixed up basically for use. The last thing I just wanted to know was that, if you don't take action, well, actually two things. One is to investigate that the ZBA meeting should be postponed until that's resolved, because we just don't want to waste people's time going through the ZBA. And frankly, you're asking us to pay for your costs for the ZBA meeting, and then you decide later on that, we shouldn't even have had that meeting. So we'd like to have that postponed if you're investigating the situation. Obviously, if the CSM is rescinded, then there's no need for that. And then finally, I just wanted to note that, the number, I think there's mention of a few neighbors. I think there's a lot of neighbors that are really concerned about this. I think what they're concerned about mostly is, obviously we were in great shock when this old forest was cut down without any notice. But what it's turned into is understanding that it appears that there was an entity that came in for a division that potentially lied to the village. And we are greatly affronted by that. And I think everybody on the board should be as well. If that's true, that's terrible for the village. And if you allow this development to go forward, it's kind of a slap in the face to hundreds of folks, including us, that went through the proper process when we put an addition on our house. We limited what we did based on the FAR and based on square footage that's allowed. And others have done the exact same thing. We've been told by the village engineer to be very careful in what we do to make sure we're complying with the law, and it's stringently enforced against us. And I experience it a lot. I experience this issue quite a bit because I'm on the ZBA myself. And I see a lot of neighbors that I want to help out. I want to make sure that they can, do what they want to do and need to do for their properties. A lot of them, are limited and they want to stay here, but they can't. They have to move. Our neighbors are likely going to move because of this. They couldn't get the addition they wanted on their house. But they followed the proper process they didn't lie, and they followed through on what, the village said they had to do, which is oftentimes either to modify what they're doing or just not go forward at all. And so I think it's incredibly important that the village is seen as a honest and true broker on these issues and doesn't treat developers, frankly, better than they treat their own residents. That's why people are concerned, I think. That's why there's so much outrage about the situation. So, but thank you very much.
Okay, thank you, John. All right, any other public comments this evening? I'm scanning.
John, I'm sorry, I received a text from John Vagley who said he wanted to speak, but he couldn't get on. I don't know if he's on there somewhere, but he couldn't raise his hand.
I see that, I see Jeannie's is on.
Well, he's usually there at Jeannie's, like John Clancy was at Christy Clancy. I think
Yeah.
he's at Jeannie's.
Okay, so.
Sorry to interrupt.
No, I know, I appreciate that. So if Johnny Vagley wants to speak, just unmute the mic and we'll provide that opportunity right now.
John, just so you know, I don't know if you guys see the participant list off to the right, but I did click to ask them to unmute and start their video. So if they could just click on that, I think they should be able to get on.
Okay, looks like they're on. Johnny, we're ready for you.
Can you hear me?
We can.
Yeah, John, first, I believe a meeting of this importance should be live. I realize that you guys in the last meeting probably had a little more democracy than you had anticipated, but democracy is always messy, and it's important to be there in person and not end up doing this virtually. I think it greatly weakens community input, and I think that's the wrong idea. I also think that the concept that you did the 24-hour notice of sending out the agenda, that's an old lawyer trick to always drop something off just before a trial and kind of catch everybody off guard. It's a fun trick that some people do, but I don't think in this village, when we're talking about transparency and involving the village and trying to get consensus from everybody, I think that's a really poor tactic. And if our lawyer is advising you to do that, my hunch is that he doesn't know the village very well, because all it does is make people more angry. Getting to the property, I'm wondering what Brian Berquist's role was. It seems almost like he's working with the developers against the residents. I mean, we're talking, first I heard that they took the stairs out and then they're going to shrink the house. That seems wrong. Then I found out they took a tread out. That seems wrong. Now apparently what they did is they put a 2x4 across the stairs and said now the house is smaller, it shrunk, and then the developer advertised the upper area as a place for kids. Well, you know what? You don't have to be a lawyer. You don't have to be an engineer. Everybody knows that's wrong. Someone can get up and say everybody followed what they needed to do. Well, that's right on the edge of unethical, and maybe it's on the edge of fraud. And I find that deeply concerning that the board, I would assume the board would find that offensive that someone played them like that. I guess my question is, if Brian Berquist is working with the developer and we're paying him, I really question his tenure with the village. But the next question, of course, is, did someone tell him to do it? Is there a wink, wink, nod, nod from people on the board, from anyone telling him to do it? I mean, at one point, John, you got up in front of the village and you did a mea culpa about this project. And I think people appreciated that. I don't know what it was that you're claiming you did wrong, if you just missed something or if you did something wrong. And I don't really care in some ways, but you got to make it right. And this is your chance to make it right. And it seems to me that at the end of the day, this is about the residents and our community. It isn't about a developer from the outside who has left a wake of chaos behind him everywhere he's been. It's about us and our community. And what he's done is lied. He hasn't been truthful, and he's going to change our village. Is the idea here that people think that by building some houses, you can build your way out of a financial crisis that we have? Because that's not going to happen. You're not going to build 100 houses. All you're going to do is change the makeup of the village in a way that is detrimental to those of us who live here. You live here, I live here, we pay taxes here, we've raised our kids here. We need to have a voice here that's louder than a developer from outside who is just playing everybody for profit. And so I think that until you address these issues, until you really try to right the wrong that was done, this tsunami isn't going to go down. People are just going to get more angry. And as an elected representative, I know it's tough, but you need to confront the problem, you need to deal with it, and you need to make it right. Thank you.
Thank you, Johnny. Are there other public comments this evening? I'm scanning. Other public comments?
This is Paul Lambert. Can you hear
Paul,
me?
would you like to speak? Go ahead.
You said go ahead.
I am concerned that there are conflicts. And this is following the last message, that there are conflicts that are existing with regard to personal, financial, or professional relationships with not just Brian Reiber, Reiber Family LLC, but the deed owner who lives on Crestwood. I would like to ask that the Board of Trustees indicate whether they have any conflict of interest now or at the time that they approve the CSM. Thank you.
Thank you, Paul. Other public comments this evening? I am scanning. There's a bunch of folks here, so I appreciate that. Other public comments? Julie, are you seeing any?
No, I don't see any hands up anyway.
Okay. I think we're going to close the public comment part of the agenda. Oh, wait, I see Jennifer Ratner Rosenhagen. Jennifer, see your hand up.
Hi, thank you.
You bet.
I just, sorry, I'm moving to a better
No,
spot.
you're fine.
I just wondered, if there's going to be a response to Paul's question. Whether, I mean, in the meeting before we close out.
Well, you know, Jennifer, I noted it. I'm certain it's an issue we'll talk. I'm sure I plan to talk about it during the closed session. I certainly don't have a conflict, but we're going to talk about it in closed session, and then we'll decide what we're going to report out as a result of that meeting with the board and with our attorney.
Thank you.
You bet. Any other public comments before we close the public comment section of the agenda?
John?
Marilyn?
John, any conflicts should not be discussed in closed session. That's a public issue and there's no basis. Closed session can often go in and out of closed session as the board discusses certain things that are proper, in their view, are properly in closed session and things that are not properly in closed session. Thank you.
Okay. No, thanks for that. Thanks for that context. All right, unless there's any other public comment, I'm going to close the public comment section of the agenda. I'll then ask the board for a motion to go into closed session. And I'll read both items for the closed session agenda. I'd also ask that the motion invite our village administrator, Brian Mooney, our village attorney, Bill Cole, and our village clerk treasurer, Julie Fitzgerald, and Chief Weitzel, if she becomes available, into the closed session. Closed session 7A regarding the CSM and Columbia Sweetbriar. Please note that the board may meet in closed session pursuant to section 9.85 1G of the Wisconsin statutes when conferring with legal counsel for the governmental body who is rendering oral and written advice concerning strategy to be adopted by the body with respect to litigation in which it is or is likely to become involved. And then for closed session, item 7B, regarding acquisition of lands for public facilities, please note that the board may meet in closed session pursuant to 19.85 1E of the Wisconsin statutes when deliberating or negotiating the purchase of public properties, the investing of public funds, or conducting other specified public business whenever competitive or bargaining reasons require a closed session. I'll also add that the item for closed session pertains to the possible purchase of real estate by the village for public facilities. I believe it necessary for the board to consider this matter in closed session in order that we can discuss the village's bargaining position with respect to its negotiations with the property owner in a manner so that the owner is not privy to the village board's direction to its negotiating team. Would someone like to make the motion to go into, Carol?
John, I just wanted to ask before we have motion and second, if there was a resident who asked how they would know the results of the closed session, and I wondered if Julie could just comment on how people could tune back in and find out what happens.
Sure. So right now we are on Facebook live streaming. This will be turned off during the closed session. When we resume, we will live stream again on Facebook. And these videos are available on the village's Facebook page for 30 days. So if you don't want to stick around and watch, you can check back tomorrow. The video will be on the Facebook page.
Thanks for that.
John,
And,
sorry, one more interruption. This is Bill Cole. On
Hey, Bill.
7A, there is a typo in the statutory section. You had said 9.85, it's 19.85, just so the
Okay.
public's aware.
Okay. Duly noted.
It's a mistake in the.
So Marilyn, if I could ask you to mute your microphone. Thanks so much. Would someone like to make the motion to go in closed session? And of course, we'll need a roll call on that. Julie Dietmar?
Yeah, I'll make a motion to go into closed session for the two items presented on the closed session, taking with us Administrator Brian Mooney, Village Attorney Bill Cole, Julie Fitzgerald, and Chief Weitzel.
Okay, is there a second, Bob?
I will second that
Okay.
motion.
And then this has to be a roll call vote, Julie?
Yes, it does. Sorry, I'm typing away here.
No,
Okay,
you're
are we
good.
ready for the roll call, everyone?
You bet.
Make sure all of the trustees are unmuted so you can reply.
Okay.
All right, Barfoot,
Yes.
Sooner,
Yes.
Falk,
Yes.
Lederer,
Yes.
Lutfi,
Yes.
Alsvik,
Yes.
and President Imes.
Yes.
Okay, that count is 7-0.
All right, thanks everyone for coming out tonight. We look forward to sharing the outcomes of these deliberations in closed session.
Okay, I will ask everyone if you can log off of the Zoom meeting, that would be helpful, so I don't have to manually remove everyone. Otherwise, I'm going to stop Facebook at this time. Again, we will resume live when we are done here. And I'm also going to pause the recording, so bear with me, John, while we get everybody out of the Zoom meeting, please. I am going to be opening the live stream here. That takes just a minute.
Yeah.
Okay, we are live on Facebook, and to the people watching, we are returning from closed session from earlier this evening. Go ahead, John.
Thank you, Julie. I want to report out on the two items that were in the closed session discussion this evening. First, regarding the CSM Columbia Sweetbriar, we want to thank residents again for your thoughtful public comments and for continuing to engage on this important issue. We obviously hear and understand the concerns that have been raised, and we take them very seriously. In closed session, the board reviewed the matter with our attorney and confirmed that under state law, when a certified survey map meets all the legal requirements, the village has no discretion, unfortunately, to deny it, and no legal authority to reverse it once it's been approved and recorded. The board acted in good faith based on the information available at the time, and while residents may pursue legal remedies, the village cannot retroactively impose new conditions or undo this approval without significant legal and financial risk. That said, this situation has clearly shown us where our ordinances and processes could be stronger, particularly regarding tree protection, public notice, and development standards. These topics are already being reviewed by the Plan Commission and the board, and we will use this as an opportunity to provide the public with more information, improve transparency, strengthen protections, and ensure future projects better reflect the values of our community. Finally, in closing, some serious accusations of potential conflicts of interest by board members were raised tonight in the public comment session. So I'd like to turn to each trustee and ask them if they have a personal or financial interest in this matter. I'll start off by saying I absolutely do not have a personal or financial interest or conflict regarding this issue. And I'll just go around. Carol?
I have no personal or financial conflicts with any of the matters at Sweetbriar and Columbia.
Thank you, Carol. Mark?
I have no personal or financial conflicts in the matter of the controversy over Sweetbriar, Columbia.
Thank you. Dietmar?
I also have no personal or financial interest in the matter of the approval or denial of this CSM.
Thank you, Dietmar. Bob?
I do not have any personal or financial interest in the property, the transaction, or the people involved in this matter.
Thank you, Bob. Shabnam?
I do not have any conflicts personally, professionally, or financially with the matter at Sweetbriar and Columbia.
Thank you, Shabnam. Kate,
I do not have any personal or financial interests or conflicts of interest with the matter at Sweetbriar and Columbia.
thank you, Kate, for that. Regarding closed session item B, regarding acquisition of lands for public facilities, the board had a fairly lengthy discussion, but doesn't have anything to report at this time. Do I hear a motion for adjournment? Shabnam, is there a second? Thank you, Bob. All those in favor, please say aye or raise your hand. Sorry about the long evening. Again, Dietmar, thanks for hanging out. It's after midnight on the East Coast. Great to see everyone, and look forward to following up on these issues and seeing everyone at the next board meeting on Tuesday, August 19th. Bill Cole, thanks for putting in the hours with us tonight. It was really great to have your perspective and your work on this, and of course, look forward to the good work ahead of us. All right, Julie, Brian, thanks again. Everyone, have a pleasant evening.
Good night.
Thank you. Good
All
night,
right, good night.
everyone.